Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with the Supreme Court's hearing on the plea seeking 100% cross-checking of electronic voting machine data against the VVPAT records. Though the hearing in the matter had concluded last week and the verdict was reserved, it was listed before the bench of Justices Sanjeev Khanna and Dipankar Datta today for directions, as the bench had certain factual queries. An Election Commission official was asked to appear before the court to give suitable clarification. The court posed several questions to the official regarding the microcontroller installed in the VVPAT and other aspects. Advocate Prashant Bhushan, representing the petitioners, raised doubts about the one-time programmable claim of microcontrollers in EVMs. He pointed out that the manufacturer had confirmed in their RTI reply the use of a specific chip in the machines which has a flash memory and is always reprogrammable. Bhushan cited the Citizens Commission report on elections indicating that 20 computer experts from top universities worldwide found that the latest chip used in EVMs was reprogrammable. However, Justice Khanna relied on the Election Commission of India's technical data and dismissed Bhushan's argument, noting that the referenced report's findings were inconclusive, using the term doubtful. Also, during the hearing, when senior advocate Santosh Paul, appearing for one of the petitioners, made a mention of the issue of EVM source code's disclosure, the bench made it clear that source code should never be disclosed as the same can be misused. To read in detail about all the technical discussion which took place in the court today, you can visit livelaw.in. A new update has come regarding the electoral bonds. A petition has been filed in the Supreme Court seeking constitution of a special investigation team to investigate the alleged instances of quid pro quo arrangements between corporates and political parties through electoral bonds donations. The petition, filed by NGOs Common Cause and the Center for Public Interest Litigation, alleges that a scam worth crores of rupees is involved in the electoral bonds matter, which can be revealed only through an independent investigation under the monitoring of the Supreme Court. It further states that the data which was disclosed to the public after the Supreme Court struck down the anonymous electoral bonds scheme showed that the bulk of those bonds appear to have been given as quid pro quo arrangements by corporates to political parties. This was either to secure government contracts or to secure protection from investigations by CBI, Income Tax Department, Enforcement Directorate, or as consideration for favorable policy changes. The data has further shown that various loss-making companies and shell companies were donating huge sums to political parties through electoral bonds. It is argued that these shell companies were used as conduits to launder illicit money through electoral bonds. The petitioner has argued that such arrangements of quid pro quo are in clear violation of the Prevention of Corruption Act of 1988. In this backdrop, the petitioners seek for a court-monitored investigation by an SIT and a direction to the authorities to recover the amounts from political parties. The Delhi High Court today remarked that hatching conspiracy against the Prime Minister tantamount to treason and prima facie, the allegations of conspiring against the Prime Minister cannot be made against any person irresponsibly. Justice Jasmeet Singh was hearing a defamation suit filed by Biju Janata Dal MP and senior advocate Pinakai Mishra against advocate Jai Anand Dehadrai. Mishra has sought to restrain Dehadrai from publishing or circulating allegedly false and defamatory allegations against him. In the suit, Mishra has said that after personal differences arose between Dehadrai and Trinamool Congress leader Mahua Moitra, the lawyer made allegations not only against her but against persons with whom she had a personal relationship, including him. That Dehadrai published various tweets against him on X platform through several coined pseudonyms such as Canning Lane and Odia Babu. Mishra has denied Dehadrai's allegation that 2 crores in cash was kept with him to make purchases on behalf of Mahua Moitra of high-value items. He is also aggrieved by an interview given by Dehadrai to news agencies ANI and PTI after hearing in his defamation case against Moitra. During today's hearing, Mishra's counsel told the court that the allegations levelled by Dehadrai were that Mishra is the architect of a conspiracy to target the Prime Minister. He clarified that his party is ideologically aligned with the BJP and the Prime Minister. Further, Dehadrai's counsel responded that Dehadrai had personally witnessed that a conspiracy hatched between Mishra and Moitra and that the same was also evidenced by way of an affidavit sworn by the businessman Darshan Hiranandani. At this point, the court cautioned that such allegations would have serious consequences as it affects the highest office of the country. The court further said that a conspiracy against the Prime Minister is actually an offence against the state. It is treason. Dehadrai was asked to file the affidavit that he mentioned on record. In an important update, the state of West Bengal has filed a special leave petition before the Supreme Court against Calcutta High Court's order invalidating almost 24,000 teaching and non-teaching jobs that were filed as a result of the 2016 SSC recruitment process. 2 days ago, the High Court had invalidated these jobs across government and aided schools. The jobs came under the scanner due to the infamous Cash for Jobs recruitment scam. The High Court found that the entire panel of the 2016 was tainted due to irregularities with the OMR sheets, many of which were found blank and liable to be cancelled. The court had also directed the appointees who were recognized to have been fraudulently appointed to return the salary that they had drawn. The SLP that has now been filed by the state of West Bengal states that the High Court, instead of segregating the valid appointments from the invalid ones, has erroneously set aside the selection process entirely, which will affect around 23,000 teaching and non-teaching staff in the state. That the High Court solely relied upon the oral arguments without the support of affidavits. It has been argued that the verdict will result in a huge vacuum in the state schools unless a new selection process is completed, given that the new academic session is approaching. And now let me tell you, former Jharkhand Chief Minister Hemant Soren has approached the Supreme Court with a fresh petition challenging his arrest by the Enforcement Directorate. He has stated that the Jharkhand High Court has not yet delivered judgment on his petition despite concluding the arguments way back on 28th February. Soren has been under custody since his arrest by the ED in January this year. On 2nd February, the Supreme Court had refused to entertain his previous petition challenging the ED arrest and had asked him to approach the High Court instead. Today, senior advocate Kapil Sibal, representing Soren, mentioned the new petition before Justice Khanna, the second senior most judge of the Supreme Court, as the CJI was in a constitution bench hearing. Sibal said that because of the High Court's refusal to deliver the judgment, Soren was in a deadlock situation, as he could neither move forward nor backward for legal remedies. But Justice Khanna refused to give any date for urgent listing, asking Sibal to mail the request to the Chief Justice's Secretariat. When Sibal said that he had already done so, Justice Khanna said that it was up to the Chief Justice of India to decide the listing date. And lastly, the Supreme Court today expressed its reservation on the explanation offered by National Consumer Disputes Redressal Commission's members for issuing non-bailable warrants against a company's directors despite the top court's order directing non-coercive steps. In this case, the top court had passed an interim order on 1st March this year that no coercive steps should be taken against the company directors in the execution petition pending before the National Consumer Disputes Redressal Commission. But on 2nd April, the NCDRC issued non-bailable warrants against the directors. Previously, the court had sought the explanation from NCDRC members. During the course of today's proceedings, Attorney General R. Venkataramani, representing the NCDRC's members, submitted that the error was inadvertent and unintentional. The court also reviewed a joint affidavit from the presiding member and the member of the NCDRC acknowledging an inadvertent error and seeking apology from the Supreme Court. They stated that they were not informed about the Supreme Court's order by the proxy advocates in the matter that day. However, the court, while expressing reservations, noted that in NCDRC's own order of 8th March, it states that a copy of the Supreme Court's order was indeed given to the Commission. Therefore, the court found it implausible to accept that the NCDRC was unaware of the top court's order. The Appellants Counsel presented the bench with a copy of an affidavit that the appellants had filed electronically before the NCDRC on 1st April. This affidavit contained the Supreme Court's order. However, the Attorney General R. Venkataramani noted that this affidavit was not found in the file. Therefore, he requested the registrar to check if it was present in the NCDRC's registry and to provide necessary instructions accordingly. Following arguments from both the sides, the court decided to postpone the matter to 3rd May. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.